Okay, we'll make a start. So hello and welcome to the AIFC Court and International Arbitration Centre webinar series 2020, New Opportunities During and Post-COVID-19. Today we have webinar 12 in our 2020 series. The topic is Dispute Resolution During and After the Pandemic, Some Substantive Law and Procedural Issues and Implications. Today's speaker is Justice Andrew Spink QC from the AIFC Court. As usual, we have 1 hour for today's webinar. Justice Spink will give his presentation and we will then open the floor for questions. Again, as always, please type your questions in the Q&A option shown at the bottom of the top or the top of your screens, and Justice Spink will answer your questions at the end of his presentation. By way of a very short update from myself, I'm happy to confirm that the Court and IAC continue to provide their services 100% online without disruption during COVID-19. As of today, we have now had 89 cases across the Court and Arbitration Centre. These comprise judgments and orders, arbitration and mediation awards. All of our services continue to be provided free of charge. In addition to our 2020 webinars programme, which now includes 20 webinars from the most distinguished common law judges from our AIFC Court, our arbitrators, leading lawyers from Kazakhstan. Without further ado, if I may, I'll hand over to Justice Spink.
Thank you, Chris. Thank you. Apologies for that for everybody. Good morning from the UK, good afternoon to you in Kazakhstan and anywhere else in that region on that time zone. It's very good to be speaking to you. I hope you can hear me clearly and see me. The topic on which I'm going to talk to you today is dispute resolution during and after the pandemic, some substantive law and procedural issues and implications. Chris is going to control the slides for me. So Chris, could you move on to the first slide, please? Thank you. So in very brief outline, what I'm going to cover over the next 45 minutes or so are the topics that you can see on this slide. First of all, just by way of brief introduction, I'm going to remind us a little bit of precisely why COVID-19 has such important implications for dispute resolution, creating potential disputes and making the resolution of disputes more difficult. Then, as a further introduction, I want to just again remind ourselves about the relevance of English law and other common law decisions for the purposes of our court, the AIFC Court, and its sister dispute resolution centre, the International Arbitration Centre in the AIFC. It's very important for us to understand and to be able to apply English law alongside AIFC law, which of course is influenced by English law as well. I'll explain a little bit more about that in due course. Then I'm going to turn to the substance of the main part of my talk, which will be to look at some, I hope, interesting commercial and property law issues and implications that arise from the pandemic, either because of the direct effect of COVID-19 on commercial transactions and contracts, so as of itself to give rise to legal disputes, or because the economic effect of COVID-19 is such as to create situations where disputes are more likely to arise, and therefore disputes in new or difficult areas of law are more likely to come before the courts. And you can see a list of the types of issues that I want to talk about. I should say at this stage that my talk will deal with some issues of substantive law, of course, but I'm trying to make it as full of examples, practical examples as possible. And finally, I'm going to think about and talk about the impact on court processes due to COVID-19, and in particular, remote court hearings, something which we've had considerable experience of in England during our lockdown. Right, so COVID-19, we all know, of course, about the deadly effects and the economic effects of the pandemic. But it's important to remind ourselves that there are two ways in which COVID-19 can have an effect on the events that can lead to the need for dispute resolution. First of all, there's the direct effect of the disease in the sense that employees are become very seriously ill, or may do. They're absent from work. The people needed to make the businesses function are not available, and that can have obviously considerable consequences for supply chains, and other forms of economic activity. So that's a direct effect due to illness. But much more important in many ways are the effect of government restrictions. On this slide, I've noted the relevant UK government restrictions, which provide for closure of businesses, restrictions on movements, and prohibition on gatherings in any great number in public. There are similar restrictions, as we all know, in most countries around the world at the moment, of varying degrees of severity and duration. But the consequences of those taken together with the direct effects of the disease are, as I've noted, the absence of employees, disruption of supply chains. The prohibition on public gatherings is an immensely important economic factor because of the inability to hold major sports events or cultural theatre, concert events, etc., cinemas, and the closure of restaurants, bars, and so on. So that's a critically important aspect of why COVID-19 is important in this context. Clearly, that leads to substantial drops in turnover for businesses all over the world and increases the risks of insolvency and at times of economic hardship and risks of insolvency. There is very often a greater focus on litigation or arbitration to resolve disputes, or indeed other forms of dispute resolution, which brings to the fore disputes over unclear, uncertain areas of law. As for the relevance of English law, there are two aspects to this. The first is that, as you all know, a very, very large number of commercial contracts around the world are governed by English law. And it's perfectly feasible and indeed to be encouraged that the AIFC Court or the AIFC International Arbitration Centre will resolve disputes where contracts are governed by English law, and clearly then all the principles that I'm going to talk about and the practical examples that I'm going to give would be directly relevant. But of course, even where contracts are governed by AIFC law, English law and other common law decisions are of relevance. The relevant provisions in the constitutional statute and the court regulations, that's Article 13.6 and Regulation 29.2 are well known to you, I'm sure, but I've set them out there to remind us that the court shall be guided by decisions of the court and decisions made in other common law jurisdictions. Interlaced with that, in this particular area of economic activity and contract law, commercial law disputes, are various important AIFC specific laws lying over what might be the common law position. Examples are given on this slide. The AIFC contract regulations. There are some similarities to English law, but there are some very important differences in some respects. The implied terms in contracts and unfair terms regulations, damages and remedies regulations, and then interestingly the trust regulations, note regulation 7.1, the common law of trusts and principles of equity applicable in England and Wales, supplement these regulations except to the extent modified by them. So again, directly affected by common law in relation to trusts. Please may I have the next slide. Thank you. The next section of my talk will focus on commercial and property law issues and implications. I've divided this up into 5 main categories: frustration and force majeure, insurance claims, consideration, crypto assets and smart contracts, and then financial services contracts. And I'm going to take each in turn and give some examples under each. So first of all, frustration and force majeure. A brief reminder of the legal position. I say brief because in this series of talks by my colleagues and others, there's been quite a focus already on certainly force majeure and to a certain extent frustration. My colleague, Justice Andrew Smith, spoke about frustration from an English law perspective, and on slide 14 of his presentation, you'll find a very good summary of that. The important points to remember for the purposes of my talk are that frustration is an English common law doctrine developed by the judges over the centuries. It's engaged, if at all, where the contractual provisions do not provide for what is to happen in the case of some supervening event. In other words, if there is not a force majeure clause which is engaged. In that situation, there is the potential for a court to hold that a contract is discharged from further performance because of frustration. The threshold for frustration is high. It's encapsulated in the very famous dictum of Lord Simon in National Carriers and Panalpina that's set out on this slide. I'm not going to read it out in full. You can look at it carefully if you wish to do so after the talk. But what his lordship was emphasizing there was the supervening of an event, which isn't anything to do with the fault of either party and which wasn't foreseen within the contractual provisions, where there is a significant change in the nature of the outstanding contractual rights, so that it would be unjust to hold the parties to the literal sense of the contract. The other way in which that test in modern parlance is often expressed is that the supervening event must render the contractual performance radically different, the radically different test. As for force majeure, as you will know, under the AIFC contract regulations, Regulation 82, there is in fact a code set out to deal with the legal effect of supervening events. And that may be treated or regarded as a code, a force majeure code. In English law, force majeure relates to the contractual approach taken to the issue of the effect of supervening events. That is to say, what does the specific contract say about what is to happen if a particular event, often expressly called a force majeure event, occurs. The key points there are whether there is any force majeure clause at all in a contract. If there is, the first question is, does the event that's occurred fall within the definition of force majeure contained in the contract? And the second question is that if such an event occurs, what effect does it have on contractual performance and on whose performance? Now, against that background, if we could move to the next slide, I'm now going to take you through some specific examples. I've divided these into three main categories. The first is some form of public event, a sports event or a concert. Then we have several supply contract examples. And finally, we have leases. And if I could go to the next slide, we'll start with the sports event or the concert example. We can imagine here, we don't need to imagine, we know the cancellation of the Olympic Games, a Grand Slam tennis event, a rock concert at Wembley Stadium in London, or a major opera at the Opera House in Astana. In that event, issues may arise in multiple contractual contexts. There is a network of multiple contracts between different parties that relate to each of these sorts of major events. There will be the event contract itself between the venue and the promoter of the event. There'll be the media broadcasting contract between promoter and broadcasters. There'll be sponsorship contracts between companies all around the world, potentially, on the one hand, and the promoter of the event on the other hand, and also with the participating teams or the individual sportsmen or women, or the musical performers taking part. And then there'll be the supplier contracts, hospitality, accommodation, etc. If any or all of these contracts are governed by English law, we must first of all consider whether there are any force majeure clauses in the relevant contract. It's likely that many, if not all, the contracts in this situation will have some form of force majeure clause in them. And therefore, the outcome contractually of any dispute arising out of the cancellation of such an event will turn on, first of all, how that clause defines a force majeure event. Does it, for example, refer expressly to a pandemic or an epidemic, or perhaps in the alternative to government restrictions affecting the performance of the contract? And the second point that will need to be considered looking at such a clause is what effect does the force majeure event have to have on performance in order to engage that clause? Must the event render the contractual performance impossible, or is it enough for the performance merely to be hindered or delayed. Now, if the contract does expressly refer to a pandemic or an epidemic or to government restrictions, and even if it doesn't do so expressly, but it can be construed as covering such extreme events beyond the control of one of the parties or both the parties, and if also the sports event or the concert is completely cancelled, then it would seem that most force majeure clauses that one might come across would be engaged, and one would then look to the clause or to the other provisions of the contract that come into play when that clause is engaged to define what the outcome is of that event occurring in terms of who has to do what, in terms of future performance and how the losses will lie. If, on the other hand, the event can go ahead, but, for example, only behind closed doors, as football matches in some countries now are doing, for example, would that engage the force majeure clause? Here, performance is possible, but it's very different from that originally envisaged under the contract. Does that matter? That will be a question of construction of the particular force majeure clause. Turning to frustration, if there is no force majeure clause that is in fact engaged, then this doctrine may come to one or other of the parties' assistance, but only if the event was not foreseeable and if the performance obligation is now radically different, as I mentioned earlier. In terms of having a mass public gathering, such as a rock concert at Wembley Stadium, this radically different aspect would appear to be met. However, what about having the performers perform on stage with a live stream to the outside world, but with no public present? Would that meet the broadcasting obligations under the media contracts? Under English law, it might be possible to look at whether different parts of the contractual obligations can be severed from others in order to determine whether a contract is to be discharged by frustration in these circumstances. It's a complex question, and it's going to give rise, one would expect, to a considerable number of disputes as a result of that, the difficulty that I have just identified. If it's a case where the AIFC contract law applies, Article 82, then the code there will be the applicable code, informed perhaps by English law, but because of the codification of this aspect, perhaps less so than in some other areas. It's also worth noting in this context that business interruption insurance claims are likely to proliferate when events are cancelled and are likely to lead to litigation as to whether or not the insurance cover is effective or is not. I'll come back to that in due course. Okay, the next example is the broad category of supply contracts. And I've split this into three different examples: the supply chain example, the economic shock example, and the choice example. This slide explains what each of those examples is, but I'm going to move on to the next slide because the text for the supply chain example is set out again on this slide, and you can focus on it while I'm speaking about this if you wish to. But and the same goes for the other two examples that I'll come to in a moment on different slides. This example is for a contract for the supply of a mechanical device, which I've called device X, to a buyer, which requires the supplier of device X to source a key component, component Y, to enable device X to be manufactured by him. The source used for component Y is a factory in Hubei in China, which is shut under Chinese government regulations and cannot export. The question is, can the manufacturer and supplier of device X be discharged from his device X supply contract with the buyer because of the unavailability of component Y? First of all, force majeure. Is there a relevant clause in the supply contract between the manufacturer and supplier of device X on the one hand and the buyer on the other? If so, does the event fall within the definition of force majeure contained in the clause? And if so, what effect does it have on contractual performance? Now, if there is a clause in the contract between the device X supplier and the buyer of device X, under which, on a true construction, if the effect of government regulations in the country where component Y is made is to cut off the supply of component Y completely. And if that, under this clause, falls to be treated as a force majeure event, that will determine the outcome of the dispute. But there are quite a lot of ifs in that. There may or may not be such a clause in such a contract. And even if there is a clause that might cover it, there are likely to be quite difficult questions of contractual construction to determine whether that clause is in fact engaged. Of course, the fact on my example that the supply chain is completely cut off, so the manufacture and supply of device X is completely impossible, would tend to engage most types of force majeure clauses that you would see, all other things being equal. But it might be more difficult depending on the type of clause that there is in the contract. If, changing the facts of my example slightly, the effect on the factory in Hubei is not to cut off the supply chain completely, but just to make it more difficult to supply in the quantity required. If there's no force majeure clause that's engaged, we look at frustration, and the outcome under English law is likely to turn on the question of whether the contract between the manufacturer, the supplier of device X, to the buyer of device X, specifies the source which the manufacturer is to use for component Y. If that source is specified as the factory in Hubei and that factory closes, then the contract will be frustrated. That's the sale contract to the buyer. If, on the other hand, it doesn't specify the source of supply, then the fact that it's impossible for the manufacturer of device X to source his component Y and therefore fulfill his contract with the buyer is irrelevant, and the contract will not be frustrated. That is the traditional, conventional result from the English case law, Howell and Coupland and the Mary-Nor. The first case, there was a specified source of supply which failed, so the contract was discharged for frustration. In the Mary-Nor, there was no specified source of supply, so the contract was not discharged when the supplier was unable to get hold of cement. The risk effectively there is on the supplier. That's quite an extreme result, some might say, and it'll be interesting to see whether the courts try to take a different view and move away from that result in the current situation, but that appears to be the current position under English law. We next come to the economic shock example. This is illustrated by the contract for the supply of component Y to the device X manufacturer. There's a precipitous drop in demand for device X for reasons relating to the COVID-19 pandemic. Can the manufacturer of device X rely on frustration or force majeure to get out of accepting delivery and paying for the component Y coming out of Hubei that it no longer needs? Obviously, in this example, the factory is producing component Y, and the problem is not the cutting off of the supply chain. It's effectively the cutting off of the supplier of device X's market for that supply. In relation to force majeure, it will always, as ever, depend on what the force majeure clause says. I've given a couple of examples of good cases under English law dealing with force majeure clauses in cases of economic hardship, Thames Valley Power, and then the second case of Tandrin Aviation. This is an interesting case. The force majeure clause in that case, I haven't got it on the slide, but I'll just read it to you quickly. Neither party shall be liable to the other as a result of any failure of or delay in the performance of its obligations hereunder for the period that such failure or delay is due to, and then there's a list of various force majeure events, acts of God, insurrection, war, riots, fires, and then importantly, government actions. Then a few more events are listed, and then it ends up, or any other cause beyond the seller's reasonable control. And in this case, the seller was supplying an executive jet to the defendant buyer. There was a financial crash in 2008, which made it economically incredibly difficult for the buyer to be able to afford to pay for the plane. The buyer tried to get out of having to do so by reference to this force majeure clause. The court held that on a true construction of the clause, it only was engaged in cases where there were events that affected the seller's performance. That's because of the words beyond the seller's reasonable control. And the financial crash was not affecting the supplier of the executive jet's performance because he was ready, willing, and able to deliver. It was only affecting the buyer's side of performance. And so they couldn't rely on that clause. The judge went on to say that a change in economic or market circumstances affecting the profitability of a contract or the ease with which the parties' obligations can be performed is not regarded as being a force majeure event. So that's the general position under English law, but it will depend on the particular terms of the particular clause. Interestingly, the judge also said that the force majeure clause in this case might be engaged if the seller were unable to deliver the aircraft due to a pandemic causing a dearth of delivery pilots. So there is a good example of, that's not obviously what happened in this case, he was speculating, but there's a good example of a direct effect of COVID-19 causing a non-availability of key employees and impossibility of performance. In terms of frustration, if there's no force majeure clause that is engaged, under English law, economic harshness of performance is generally insufficient to make performance obligations radically different. That's the test I've outlined before. Authority for that is Davis Contractors and Fairham. Moving on to the next example on the next slide. This is what I've called the choice example. What happens here is that our manufacturer of device X decides to shut his factory for the safety of his employees, despite not being required to do so by government regulations. And he seeks to be excused from having to take delivery of or pay for any further supplies of component Y, and to be excused from performance of the supply contract for device X to the buyer. Under force majeure, it's much as with the supply chain example that I've already given. Is there a relevant clause? How does it define a force majeure event? Is it engaged? If it's a frustration case because there is no force majeure clause that is engaged, the traditional approach under English law, if applied to our example, would hold that the inability of the manufacturer or supplier of device X to take delivery of component Y or to supply device X onto the buyer results from his choice. And so that would not engage the doctrine of frustration. The example I've given is the Super Servant 2, where there was a contract which provided for one of two specified ships, Steamship 1, Steamship 2, to carry the oil rig. The carrier had also entered into other carriage contracts with other parties. SS2 was lost. SS1 had been allocated by the carrier to other contracts. The carrier unsuccessfully sought to argue frustration because the carrier was held effectively to have made a choice which made it impossible for him to perform the relevant contract from which he was seeking to be discharged. The interesting question is whether, in the current circumstances, a court would take that traditional approach, which is an economic approach, an economic choice approach, or whether it might take a different view on the basis that, in our example, the manufacturer of device X, although not required by government regulations to close his factory, was or may have been acting under, for example, a health and safety duty to his employees to close the factory. And whether that would produce a different result is an interesting point on which to speculate. Moving on, please, Chris, to the next slide. We can deal briefly with leases. I don't propose to dwell on this. The English courts have historically been reluctant to hold that the doctrine of frustration is engaged in the case of leases where occupation of the premises becomes difficult or impossible. In principle, frustration can apply. The House of Lords case of National Carriers and Panalpina establishes that, although on the facts of that case, the court held that frustration was not engaged so as to frustrate the lease. In the much more recent case of Canary Wharf against European Medicines Agency, the judge held that a lease was not frustrated in a case where the tenant contended that as a consequence of the decision of the UK to leave the European Union, that tenant, which was an agency of the European Union, felt the need to relocate away from the United Kingdom and wanted to get out of the rest of its lease, which was for a term of 25 years that had been granted in 2014. So there's a long time still to go at the time of this court decision. The judge held that on the facts, the changes brought about by Brexit didn't render the tenant's occupation of the premises impossible and did not render the tenant's performance under the lease something radically different. So that's the test that I've mentioned a couple of times. Nonetheless, in the context of COVID-19, in principle, it may be that leases will be capable of being held to be frustrated. Key factors are likely to be the reason for the disruption to occupation of the premises. Is it government restriction? Is it choice? The length of the disruption and the time left to run under the lease. Obviously, if it's a short period of disruption in the context of a lease with a long time left to run, that would seem less likely to enable the doctrine to be engaged. On the contrary, if it's a very short remaining period of the lease, it may be that that would be an easier case in terms of frustration. Insurance claims. It's self-evident, I think, that there are likely to be a plethora of insurance claims. Indeed, there already are, from my knowledge. And in particular, in the context of business interruption, many businesses have insurance covering them for loss of earnings, loss of business in certain circumstances. And I've given just one example of a real business interruption clause, this one from a retail business premises insurance policy. You'll see it's called a denial of access clause. The loss that is covered is in consequences of B, restrictions imposed by order of a civil authority consequent upon any sudden and unforeseen emergency which is likely to endanger life. Now, you might think that's engaged by COVID-19, but there's, as ever, an exclusion clause, little Roman 2. This shall not include loss resulting from strikes, picketing, or notifiable diseases. So if it's a notifiable disease, then you are excluded from being able to claim. The question on a clause such as this in the current circumstances is whether that notifiable diseases exclusion is engaged in circumstances where COVID-19 was not a notifiable disease when the policy was entered into. Does that matter or not? It became a notifiable disease on the 6th of March 2020, and the shops were ordered to be closed by the UK government on the 23rd of March 2020. So as at the date of closure, COVID-19 was a notifiable disease, but it wasn't at the beginning of the period of the policy. What's the outcome there? There are going to be numerous disputes of that sort for a long time to come. Mention here of a fundamental and deep-rooted concept in English law, that of consideration, which is a concept that's absent from contract law under the AIFC contract regulations. But it lies at the heart of contract law in England and Wales traditionally. The principle is that enforceable contracts, which are not contained in a deed, to which different rules apply, rely on valuable consideration passing between the parties to the contract. What amounts to consideration is effectively a legal fiction, which the courts have struggled to define. There are two lines of cases in English law, one dealing with part payment of an existing debt, where the parties agree that the debt will be rescheduled or be paid in part, and where traditionally under the doctrine established clearly in Folkes and Beer in 1884, that is not good consideration and that will not be an enforceable agreement. Contrast that with the cases where what is agreed is that more will be paid than originally agreed for the performance of an existing contractual obligation, and that is good consideration, or maybe where there is some practical benefit that accrues to the parties through that further agreement. That's the Williams and Roffey brothers case. That there is much weight of opinion in English amongst English contract lawyers that this distinction does not reflect the realities of modern commercial life, and after COVID-19, with the economic impact that this has given rise to, agreements to reschedule or debts or part pay debts may be even more common. And this question, it seems, is likely to come up for review at some point, and it may be that COVID-19 is the event that produces the case that eventually leads to the law being reconsidered, so that this distinction is removed, such that in all such cases, consideration is held to be present. In the meantime, from a practical perspective, any relevant contractual variations of this sort, i.e. part payments of existing debts or rescheduling, could, for safety, be made by deed, to which the consideration rules don't apply. And now I'm going to mention a very interesting and important and rapidly developing area of the law in all jurisdictions around the world, both common law and civil. That's crypto assets and smart contracts. A key question has been whether crypto assets are to be treated in law as a form of property. Another key question is whether smart contracts fulfill the traditional requirements for a legally binding contract. Both questions have been addressed in the UK in the document referred to on this slide, the legal statement, but that's not judicial authority. That's just the opinion of eminent lawyers on the task force. It has been influential, though, in some of the court decisions that have followed it. In particular, in the New Zealand case of David Ian Rusco and Michael Russell Moore in Cryptopia, the facts of which I've set out on the slide, and I'm not going to read them out to you now. You can go back and look at them, but essentially, the key first question is, are crypto assets to be treated as property, is a question that was directly addressed in this New Zealand case. It was a common law decision, obviously from New Zealand, and it confirms the English law view set out in the opinion in the legal statement to which I've referred. The significance of this judgment is that it's the first fully reasoned judgment in the common law world on how crypto assets should be characterized. As the court observed, the status of cryptocurrencies as property has attracted significant attention around the common law world in recent years, without, it seems, as yet receiving a definitive judicial analysis, which is exactly what the judge in this case provided. Why is this such an important issue? Well, first of all, it illustrates an important point about the place of the law in the modern, fast-developing world, digital world. The law needs to move on and to provide structures so that the processes and mechanisms deployed in the digital world are controlled and given coherence and order without being reduced to some form of irrelevance by the inevitable march of digitization. Secondly, in the particular case of crypto assets and whether they should be treated as property, as you'll probably immediately realize, this is critical in the context of remedies. Proprietary remedies are powerful. They're available not only against the person threatening one's relationship with the thing, but against the world at large. And that's particularly important in normal times, but even more so post-COVID-19, given the number of insolvencies that are likely to be produced, because a creditor's property rights are protected on the debtor's insolvency if the asset is property in a way that his personal rights are not. The monetary value of the result and how it would have changed in the New Zealand case to which I've referred, which is the point in the last bullet point on this slide, illustrates how important the outcome of that dispute was in this particular case. And the third reason why this is important is that there is a lot yet to be worked out, not only in the case of crypto assets, in smart contracts, and other digital forms of transaction. There is no fully reasoned judgment yet outside New Zealand, and certainly not in an English court, on the question of whether crypto assets are property. And very interestingly, the cases in other countries on this particular issue are divided. In the Court of Justice of the European Union, the Spanish Supreme Court, the Japanese courts, there have been cases holding that Bitcoin, which is a form of crypto asset, does not have proprietary status, so contrary to this New Zealand case, whereas in Dutch, Russian and Italian courts, the rulings have gone in the opposite directions. And the differing approaches and remedies in one jurisdiction over another will inevitably give rise to conflict of laws complications, which is going to be an overlay of concern and complication in these cases going forwards. Financial services, I'm not going to dwell on this at all in view of the time. I'm just going to flag up two out of a plethora of issues that may give rise to dispute and litigation going forward. The effect of material adverse change clauses in, for example, loan agreements, overdraft agreements, which cover the adverse change in a party's financial position. The construction of those clauses in the current circumstances is going to be very important and likely to give rise to dispute. And secondly, the LIBOR transition issue. LIBOR is the world's most widely used interest rate benchmark. It's going to be discontinued from December 2021. It's a global issue. It's used all over the world in contracts. Lots of contracts were entered into when the parties didn't foresee a permanent cessation of LIBOR. And for the reasons that are set out on this slide, which you can read for yourself in your own time, but essentially the fact that the parties have to agree to a replacement to LIBOR, and what that replacement is going to be critical in terms of outcome for all the parties, all the more acute under COVID-19. That's likely to lead to disputes. Right, I'm going to finish briefly by just saying a few words about the impact on court processes as a result of COVID-19, and in particular, remote hearings. First of all, just to emphasize that, as I'm sure you all know, the AIFC Court and the IAC in the AIFC are fully open for business and extremely experienced in dealing with all sorts of issues arising out of the use of IT in proceedings. I was the judge that was lucky enough to be asked to, in place of our Chief Justice at the time, to launch the e-justice system last February 2019. So I'm particularly aware of and interested in the systems that we have up and running. In the UK, remote hearings have been common throughout lockdown, as I'm sure you're aware. In terms of the feasibility and appropriateness of hearing cases remotely, as for holding conventional court hearings, that's clearly impossible while court buildings are closed. Even if they're not closed, there's a risk to health potentially, with problems with social distancing in some courtrooms. And in most cases throughout lockdown, hearings in person have been completely impracticable. And the question of whether to direct a remote hearing or simply adjourn a listed hearing or trial until courtrooms become available is an exercise in judicial discretion, in which the disadvantage engendered by postponing the trial dates will have to be weighed against the difficulties arising from proceeding with a hearing remotely. So balancing the difficulty of conventional court hearings against the feasibility of remote hearings, there really have been in the civil courts dealing with commercial disputes in England, and would be in the AIFC court in a similar situation, no substantial problems in hearings without witnesses, certainly if not too document heavy. But even where they are document heavy, many successful hearings have taken place in English courts over the last 3 months. I myself have done one particular hearing with a very large number of documents and 3 parties, but no witnesses. Colleagues of mine have done 2-week cases with no witnesses and a huge bundle of documents and an even bigger bundle of authorities to take the judge through, very successful hearing. And others have done witness actions where witnesses have been examined remotely by video. And the various legal and procedural frameworks in place in England recognize all of this. The legislation effectively encourages remote court hearings as opposed to no court hearings. The civil procedure rules have been amended to bring in new provisions on video and audio hearings. And there's a protocol, the protocol regarding remote hearings, which makes it clear that it will normally be possible for all short hearings, interlocutory or non-witness applications, to be heard remotely. And it says that some witness cases will also be suitable for remote hearings. And that is my practical experience, as I mentioned, some hearings with witnesses being examined remotely have gone ahead. But interestingly, the latest development in London are hybrid hearings where a substantial part of the hearing is done remotely still in order to reduce the risks, but where certain key parts, which are usually the examination of particularly important witnesses, take place in suitably adapted large courtrooms. And I think that's going to be a template for going forward. The case management decision, which is referred to on this slide, one Blackfriars, is an interesting example of a judge in the Chancery Division in England refusing a party's application to adjourn what was a 5-week trial due to start in June. The party said that the case was too complicated, too many documents, too many witnesses, and too long to be held remotely. The court said, no, that's not necessarily the case. You have to go away and look at how it can be tried. And indeed, that trial has indeed just started remotely, or at least in part remotely. As far as the AIFC court position is concerned, Regulation 33 of the regulations says that the court may direct that proceedings or any part thereof may be conducted or continued at any place in the world on such conditions the court may impose. That's a very wide power, enabling any such arrangements that we've been discussing to be put in place. And there's a specific provision for witness evidence being given by video link in Rule 18.7 of the court regulations. Just briefly to conclude, some issues that arise with remote hearings. First of all, what I would call open justice. It is specified in the AIFC Court regulations, Regulation 32, that proceedings are to be held in public. However, the court may direct that a hearing or part of it be held in private if the court considers this to be necessary in the interest of justice. Now, if the hearing couldn't go ahead at all, it may well be in the interest of justice for it not to be held in public, but the principle of open justice, public hearings, is an important one, not to be eroded by too ready a move to private hearings because of difficulties, practical difficulties arising out of situations such as the current pandemic. There are wider issues at stake than merely the interests of the individual parties in the case. There are public interests at stake in the open justice principle. And holding a hearing remotely doesn't necessarily rule out it being held in public. The hearing can be viewed on a video in a designated courtroom that members of the public can attend, or it can be live streamed, or members of the public, including press, may be able to gain access to the Zoom or Skype for Business video session for the trial. And that's something that the English courts have been very keen to preserve. That's the principle of open justice despite remote hearings. The other issue that I've referred to on this slide is over bundles of documents. Time doesn't permit me to go into detail about this, but it's a critically important aspect of any remote hearing in a commercial case to get the bundles sorted out in electronic format in a proper, usable way. And we have gained quite a lot of experience of that over the last 3 months, with a lot of tips that can be given to make hearings go much more smoothly. And finally, with apologies for the phone ringing in the background, there are obvious practical issues that arise. Background noise or other interruptions was one of the points I put in my notes, which you've just heard coming on. My final slide, if we can turn to that now, is a light-hearted slide illustrating 2 of the problems that can arise in remote court hearings. The first, on the left-hand side, is a real discussion that took place in a telephone hearing early in April, where one of the lawyers appearing in the hearing had some geese which interrupted the proceedings, as you can see from the exchange between the judge and counsel. And on the right, the ever-present problem of a young person running in at a crucial moment to a court hearing or Zoom conference.